Hello, this is Anna Pinedo. I'm a partner in the Capital Markets Group at Mayer Brown. And during this micro talk, I'm going to be discussing the most recent statements by the staff of the Securities and Exchange Commission regarding special purpose acquisition companies, or SPACs. On March 31st, 2021, the staff of the Division of Corporation Finance issued a brief statement regarding special purpose acquisition companies, or SPACs. While the statements that the staff of the Division of Corporation Finance issued didn't really contain any new information, they're significant in the sense that the activity in the SPAC market has been record-breaking in 2021. And it's obvious that the staff of the Division of Corporation Finance felt it was important to address market activity and to essentially issue a warning to the management teams and stockholders of private companies that are considering a potential merger with SPACs. Among the things that the division commented on in its statement issued on March 31st are the restrictions that are applicable to SPACs. And in the statement, and as we mentioned in various of our materials available in the resources section of our free writings and perspectives blog, are the fact that SPACs are considered, for all intents and purposes, shell companies under the SEC rules. And as shell companies, they are also considered ineligible issuers for SEC purposes. And they remain ineligible issuers for SEC purposes even after the initial business combination is completed. That means that even after the initial business combination is completed, or the de-SPACing transaction is completed, the combined company going forward is still going to be subject to a number of restrictions. The staff of the Division of Corporation Finance highlighted some of those restrictions in its public statement from March 31. For example, the staff highlighted that the combined company is not eligible to use Form S8 for at least 60 days after the filing of the Super 8K, or the Exchange Act report that contains the Form 10 type information. The combined company can't qualify as a WICSI until it ceases to be considered an ineligible company. It can't use a free writing prospectus, and so on. So quite a number of restrictions that are that pertain to an ineligible issuer. And you can find a full discussion of all of those in our What's the Deal on SPACs. In addition, in the statement issued by the Division of Corp Fin, there was an additional set of warnings regarding the obligations on SPACs and on the combined company regarding the books and records, and regarding internal control over financial reporting. So the staff of the Division of Corp Fin reminded the management teams of private companies that public companies are required to maintain books and records with sufficient specificity and in sufficient detail that they will provide for and accurately reflect all transactions that the company enters into. In addition, the staff reminded private companies that SPACs are not exempt from the obligation to comply with the requirement to maintain internal control over financial reporting. So essentially, it was a reminder that by merging into a special purpose acquisition company, it's really not a shortcut, and that public companies are subject to all of the same requirements that they would be subject to if they went public through a traditional IPO. So again, these may be things that were already well understood. yet they serve a useful purpose in what many think is a somewhat overheated market. The next statement that was issued the very same day, on March 31, was a statement by the staff of the Division of the Office of Chief Accountant. And naturally, the Office of Chief Accountant focused its remarks on accounting issues, and in particular, again, sort of was addressing its comments to the management teams, and in particular the CFOs, the boards, and in particular the audit committees of private companies considering a merger with a SPAC, and reminding these companies that in connection with the actual merger with and into a SPAC, there are often some very tricky and complex accounting issues that come up, and that the Office of Chief Accountant is obviously always available and willing to discuss with registrants the complex accounting issues that come up in terms of the reverse merger issues, in terms of who is or who isn't the accounting acquirer, the types of financial information that need to be presented, and so on. The bulk, though, of the statement from the staff of the Office of Chief Accountant, though, focused on the importance placed by the Securities and Exchange Commission on high-quality financial reporting and on the integrity of financial reporting. And in that regard, it focused on reporting standards and on making sure that it was well understood that the combined company would have an obligation, again, to maintain internal control over financial reporting, ICFR, and disclosure controls and procedures once the merger was completed. And that both of these, ICFR and disclosure controls and procedures, really both entail significant time and effort. Both require having a staff, having systems in place, oftentimes entail bringing in outside advisors and experts. And many of the private companies that are contemplating merging with SPAC counterparties don't necessarily take all of this into account at the time that they are contemplating some of the exuberant valuations that we're seeing in the SPAC market. Finally, the statement from the Office of Chief Accountant ends with a very direct appeal to boards and to audit committees, reminding boards directly and audit committees very specifically that boards have duties and audit committees specifically play an oversight function, a very specific and very vital role in terms of being responsible for oversight over a company's financial reporting, being responsible for ensuring that indeed the company does have effective internal controls and is engaging properly with its outside auditors, is setting appropriate expectations regarding financial reporting, managing the audit process, and setting an appropriate tone at the top with respect to all of these financial issues. So all of these statements really show that the Securities and Exchange Commission and that the staffs of both the Division of Corporation Finance and the Division of the Office of Chief Accountant are keeping a close eye on what is happening in the SPAC market, as are we through our regular posts on our blog, Free Writings and Perspectives, which we hope you will subscribe to for more information on SPAC and SPAC-related developments, as well as other securities developments. So thanks so much for joining us.